Okay, good morning. We are now on the record for Wednesday morning civil docket, July 21st, 2021. I'll begin with quick announcements. Attorney Juan Ramos.
Good morning, Judge. I'm here on number 1 on your civil docket.
Okay, that is F3461-20-9 in the matter of the marriage of Cynthia Cardona versus Jose Cardona Jr. What is your announcement, Counselor?
Your Honor, Juan Ramos here on behalf of Mr. Jose Cardona. Your Honor, we're still trying to get some pay information to do to exchange over to the Attorney General's office for back pay. And so we're hoping to do that soon. We've actually requested it from Mr. Cardona's employer, proof of income.
Okay, I think Mr. Alcantar is here from the OAG. Is this the case that you're on, Mr. Alcantar?
Yes, Your Honor, Elias Alcantar at the Office of the Attorney General on the same case.
Okay, and Mr. Ramos, you're representing Mr. Cardona, is that correct?
Yes, Your Honor.
And is Cynthia Cardona present?
I don't see her.
I know, is she still pro se?
Yes,
I
Your
believe
Honor.
so, yes.
Okay, and how much time are you requesting, Counselor?
We submitted a request to Mr. Cardona's employer. If we can have another 30 days, Your Honor.
Okay.
August the 25th, Judge?
Okay. Okay, August the 25th at 9:30.
Thank you, Judge.
Okay, anything else?
No, I have
Nothing
nothing
further
further.
from-
May be excused.
Certainly may.
Thank you, Judge.
Thank you, Judge.
Okay. F2456-20-9, Jose de Jesus Carizales versus Belinda de Jesus Coronado. Ms. Gonzalez? Attorney Savannah Gonzalez? Okay, I'll recall that case. CL 21-2070-I, Jesusa M. Perez versus Stephanie Benavides.
Good morning, Judge Andres Ramos. I'm here standing in for Renee Flores for Jesusa Perez. We have a motion to set aside a default judgment, Your Honor.
Okay, and is Stephanie Benavides present? Can you please unmute yourself? Just hit the microphone, ma'am.
Oh, sorry, Your Honor. Good
It's
morning.
okay. Good morning. Ms. Benavides, are you still representing yourself?
Yes, Your Honor.
Okay, Mr. Ramos, I don't have access right now to my Odyssey because like I told you, my laptop is not working. But
Yes, sir.
just for purposes of the record, did you send notice to Ms. Benavides of your motion to set aside the default judgment?
Yes, Your Honor.
Okay.
it's just
And
correct.
was that notice done within the required amount of time?
Yes, Your Honor.
Okay, so go ahead, Counselor, you can put your argument on the record.
Judge, essentially what's occurred, this was a forcible entry and detainer that was originally filed in JP court. Procedurally, it ended up in Your Honor's court after appeal. And I actually don't even think the JP court heard it on its merits. It kind of got kicked up here before. It was kind of I couldn't really make sense of what that was. But regardless, Judge, it was in Your Honor's court set for June the 30th. Ms. Jesusa Perez, the plaintiff in this case, she did receive notice. However, Judge, the notice and the order that was signed was an order that did not include Zoom information. It was a standard order that said a hearing before the Honorable County Court at 9. Ms. Perez appeared at the courthouse and was kind of looking around and couldn't find a pending court setting or a matter being heard. In all that, Judge, is when she got notice that it was on Zoom, that morning, was then able to download the app, figure it all out, and get on, Judge. All we're asking for the court is to take judicial notice of the order setting the hearing, which was on June the 7th, which is on the docket sheet, Judge. And I know the court doesn't have the Odyssey before her, but as an officer of this court, I've got it open on my screen as well right now. The entry on June the 7th on the docket sheet is the order setting the hearing, which does not include the Zoom information, which, as we know, Judge, we don't get the Zoom information usually till right before. And again, pro se defendants and plaintiffs don't have the advantage that we have as the common practice. respectfully, Judge, we're just asking the court to set this on the docket based on inadequate service or incomplete service, I guess. The confusion, it was not based on conscious disregard, Judge. As soon as she found out that there was a default entered against her or that the hearing proceeded without her, she contacted us and we filed this motion with the court. So we're just asking that this be given the opportunity for the court to hear this matter on the merits. And upon doing so, we believe that the court will grant petitioner's requests. And
Okay,
Ms. Jesus Perez is here on the screen, Judge. She's ready to testify to all these matters that I just said before the court by proffer. If the court would accept the proffer, fantastic. If not, Ms. Perez can confirm the matters that I just advised the court of.
okay. No, the court will accept the proffer and take judicial notice of the order setting hearing. Ms. Benavides, do you have any response?
Yes, I want to let the court know that I have a case open with the Texas Renters Relief Program. I have an ID number. And I was made aware that the Supreme Court just entered the eviction date till October. Now, we're in the process of getting help to get relief for Ms. Jesus Perez, the rent that was owed. I have an ID number, a case ID. I have it all
Okay,
ready.
hold on, Ms. Benavides. Those are all arguments if I reopen the case and set aside the default judgment. But I need to hear or give you an opportunity, since you're representing yourself, to give you an opportunity to respond to Ms. Bettis's motion to set aside the default judgment.
I was only notified through court for the Zoom, not for the default.
Okay, you were notified. Okay, did you receive notice of today's hearing? Obviously you did because you're here. Is that correct? Okay, so you need to understand that Ms. Bettis and her attorney have filed a motion to set aside the default judgment that was entered previously. Okay, now, as an officer of the court, Mr. Ramos is telling the court that they filed all of that within the required amount of time. Okay, so she has a right to file that. You have a right to contest it. So I'm just asking you if you have anything to add or if you have any response to Ms. Bettis and her attorney filing a motion for me to set aside the default judgment.
I contest it.
Okay, all right. Okay, the court, in consideration of the arguments that have been presented by the movant in this matter, the court is going to grant movant's request and set aside the default judgment. If you can file an order resetting hearing for the previous hearing, and we'll set you, Mr. Ramos.
Yes, Your Honor.
And that Ms. Benavides, I encourage you to reach out to Mr. Ramos and Mr. Flores. And
I have a police report, Your Honor. Sorry.
okay, no. You need to, since you're representing yourself, you are held to the standard of an attorney. So before you come back to court the next time, I'm encouraging you to call Mr. Ramos or Mr. Flores, their office, and you can give them that information that you were just stating that you had. What they do with it, I have no, it's not up to me what they do with it.
Okay.
But if you're going to want to discuss it at the next hearing, they need to be made aware of it.
Yes.
So anything that you want to discuss, police reports, incident reports, an open case with the Renters Association, anything like that, you need to get that to the attorney's office as soon as possible, because that is more or less what we consider informal discovery. And he needs an opportunity to check all of that out, okay?
Yes.
And that way, you never know. I'm not saying it's going to happen, but you never know. You may even come to a settlement agreement. Because I do recall that you had some very nice things to say about Ms. Bettis at the last hearing. So, okay. So now you're going to talk to them. We're going to have another hearing on the matter of whether or not you are going to have to be removed from the property and on what date, if that happens. But Mr. Ramos is not gonna know all these things that you are talking about unless you give him that information, okay? Okay, Ms. Rivera, were you gonna say something?
Yes, Your Honor. Can Ms. Benavides provide us with a working email?
Yes, ma'am.
Okay, go ahead. What's your email address?
It's amarellehubs@outlook.com. AMORELLEHUBBS@outlook.com.
I'm sorry, what was after the B?
It's double BS, as in Sam.
Okay. At outlook.com.
Yes.
And I took note of that email address as well, Judge, and we certainly will send her an email so that she'll have a mode of communication with us as well.
Okay, okay, you can get your order filed and then I'll sign off on that.
Thank you, Your Honor.
Okay, anything else?
That's all we have, Your Honor. Thank you.
Okay, thank
How
you.
much time do I have, Your Honor, to seek
Well,
counsel?
Okay, so Mr. Ramos is gonna file an order resetting hearing. He's gonna include your email address on there. So then when you get that date, that's gonna tell you how much time you have. Because I can't give that to you right now,
Okay,
okay?
Thank you, Your Honor.
Okay, y'all have a great day.
thank you,
Okay, and you're excused.
thank you.
Okay, F 3808-18-9 in the matter of the marriage of Blanca Gomez versus Rene Guillen.
Judge Avelino Hossa for Rene Guillen. He's present on the Zoom, Judge. He's on mute at this time.
Good morning, Judge. Pilar Espinosa for Ms. Gomez, and she's present.
Okay, so then are we still having a contested hearing, gentlemen?
No, Judge, I don't believe so. Your Honor, if I may respond, we went to mediation on the 19th of this month. We did not finish mediation because of one issue was still pending. My client was adamant that he wanted the children to confer with the court. That was a motion that was filed back in March of this year. The court was supposed to, I believe, meet with the children on the 6th of this month, but something happened, it did not occur, then the 7th, and it did not occur. And so that is still left pending.
Well,
My
I believe I'm sorry, Mr. Reynosa, it didn't occur because there was a motion filed by your opposing counsel that he wanted my court reporter there. And I'm gonna hold that for a hearing. Because
That's correct, Judge. I'm getting to that point. That is correct, Judge. Mr. Espinosa filed a motion, an agreed motion to transcribe an interview with children in chambers. There was no order attached to that motion. That's my understanding why the court did not set it. There was no order attached. So basically, the request we had for the kids to confer the children did not occur. Now, after the mediation, my client was adamant about the court to confer the children. My understanding is at this moment right now, my client is asking me to waive that request for the court to confer the children. My understanding, he spoke to the girls that are in question. The girls are adamant to him that they want to stay with their mother. So I want to ask my client right now, just we're in two separate rooms. I do want to ask my client, Rene Guillen, if he's asking to waive that request, because I don't want to come back next hearing and say, why didn't we interview the children in chambers, Judge?
Okay, Mr. Guillen, can you hear us, sir?
He's strictly a Spanish speaker, Judge, so I need to ask him in English and
Sure. Ms. Castaneda, can you please ask Mr. Guillen if he can hear us?
Mr. Guillen, ¿nos escucha?
Sí.
Yes.
may I ask the question, Judge?
Yes.
Mr. Guillen, is it your request today that we waive our motion for the court to confer with your two daughters?
Mr. Guillen, ¿es su decisión de ahora pedirle a la corte de pasar la cita del juez hable con los niños?
Había dicho que para hablar con los jueces, por las niñas me hablaron y quieren estar con su mamá y pues las voy a dejar que estén con su mamá y que vengan los acuerdos que vayan a hacer, porque ellos me lo pidieron. Primero la niña chiquita siempre me decía que quería estar con su papá en la casa y todo, el niño grande.
Ok, ahorita, Mr. Guillen, es que como se va a traducir, lo tiene que decir despacito y en pedacitos, por favor, ok?
So I spoke with the children and they want to stay with their mother.
That's a good synopsis. Okay.
And Judge, may I have this, Your Honor? The translation was pasar basically means to pass. I rather have it more stronger in Spanish. To waive is renunciar. Can we have basically Mr. Guillen is basically renunciar, waiving the motion, Your Honor. So then that makes it more clear for the record, Your Honor.
Okay. Ms. Castañeda?
Mr. Guillén, la pregunta es que si está usted de acuerdo a renunciar.
¿Cómo?
For the judge to speak with the children.
Para que los niños hablen con la juez.
Pues ya dejarlos así, renunciar, porque las niñas ya hablaron conmigo y pues lo mejor era para ellas era lo que ellos querían. Y yo entendía desde el principio que querían estar con su papá. Ahora quieren estar ellas con su mamá y el niño pues, grande está conmigo. Él quiere estar ahí. Y fue la decisión de ellas porque yo no las estoy involucrando en nada. Ellas son decisión de ellas y por lo mejor para ellas.
Okay. Go ahead. Ms. Castañeda.
Yes, yes, I'm gonna go ahead and waive it. The kids want to stay with their mom.
I believe it's my understanding the girls want to stay with the mom, the boys staying with dad. So, Judge, with that information, we need to go back to mediation, Your Honor. Cynthia started. We had like an hour mediation, and we took a break because my client was adamant he wanted the kids to speak, well, the girls to speak with the judge. Now he's renouncing it. We go back to mediation, Judge, as the court ordered. And Cynthia is asking us to go back within 30 days, Your Honor.
Judge, if I may make a quick announcement.
Sure.
I agree that we did have mediation. We did make a good faith effort and a offer. We did not get a counter offer. So the mediation kind of stopped. But I do agree with Mr. Hinojosa that I think if we go back to mediation, I think we can hopefully resolve it because now it may just be a child support situation and a visitation schedule.
Okay. All right. Well, then why don't you all conclude your mediation? I think both of your clients have seen enough of this court's temperament to know how I think, and I have had a talk with your clients on more than one occasion. So hopefully they'll be very reasonable. So you all go back to mediation, notify us as soon as you're done, go back within 30 days. And what I'm going to do is I'm going to go ahead and set you for a status hearing on August the 25th at 9:30. If you're ready to finalize at that time, then let us know. And then we'll go ahead and do a final. But other than that, I just don't want to lose track of you.
Thank you, Judge.
Thank you.
Okay. All right. Best of luck to you all.
Thank you, ma'am.
Okay. Everyone is excused.
Thank you.
Okay. Let me call your case, Ms. Williamson and Ms. DeLuna, before Little Mermaid runs out in the other room and your niece comes back in.
Yes.
So F0981-15-9 in the matter of the marriage of Victor Alfonso Cifuentes versus Elda Valdez.
Good morning, Your Honor. Lucy Williamson here for Victor Cifuentes, the father and husband.
And Jessica De Luna, Your Honor, for Elda Valdez, who she's logged in on Zoom as well, Your Honor.
Okay.
Mr. Cifuentes is here in my office, Your Honor.
Okay, and what are the announcements, counselors?
Your Honor,
Your
it
Honor,
could be contested.
Okay.
It is a contested off of my motion, Your Honor, for a modification on the temporary orders, and it's in regards to travel to Mexico is the main topic.
Okay, and have you all gone to mediation on this, or it's just that one topic?
No, Your Honor, we have not had an opportunity to go to mediation on anything. This case has been going on since 2015. I would ask, this thing needs to be over, Your Honor. If you could just set us for a DCC or give us a final date so that we have to mediate it, kind of put pressure on both of us. I mean, it's not, and COVID, I know, has caused even more delay. This matter needs to be brought to an end.
And I agree, Your Honor. The only issue I have with Ms. Williamson's request for a DCC and moving forward is the Mexico issue, Your Honor. That's not something that I would want to wait till we can mediate and such, as he still has a child and I guess is going to continue to have the child throughout the month of July. The child just returned back from Mexico yesterday, and it's an issue that we have. With that, Your Honor, she was taken to a hospital in Mexico, from our understanding as well, and my client has yet to have that information given to her by Mr. Cifuentes.
Okay. So first of all, okay, so are both of your clients Spanish speaking?
My
No, Your
client
Honor.
is, Your Honor.
Okay.
Now,
Now-
my client speaks Spanish and English. He was a teacher in La Jolla, so I assume he also knows some English, Your Honor, but
Your
majority.
Honor, Your Honor, he was an assistant in a kinder class. So no, his first language is Spanish, and he speaks much better in Spanish, understands. And when we've done any other hearing, it's always been in Spanish, and he has been translated, Your Honor.
Okay, let me ask this, okay, because for any contested hearing where you will need an interpreter, that's the responsibility of the parties. I'm only required to provide an interpreter for prove-ups, for something quick, for translating a situation like that happened prior to yours. But for a full-blown contested hearing, I'm not required to provide an interpreter, and I've already checked into that, okay? Because it gets a little, it gets a little dicey, because you really need some accuracy in case you decide that you're gonna do something with my ruling, so that's where it becomes important. Now, for purposes of today, what's the one, is it only the international travel issue that we're having a problem with today?
Your Honor, the immediate relief would be that. I mean, there's other
Okay.
issues, but there's things that we could resolve through mediation or a contested hearing at the end. The one thing that's the most, I guess, pressing would be the Mexico.
Okay, now let me ask you, Ms. Williamson, or let me have well, I don't even know if it's proper. Let me just go ahead and ask you, and you can ask your client, okay?
Yes, Your Honor.
His visitation is going to end, if he's going by standard, on July 31st. Is that correct?
That's
Okay.
correct, Your Honor.
Between now and July 31st, does he plan to travel into Mexico again?
Yes, Your Honor.
Okay, then we're gonna have a hearing. Okay, so I'm gonna recall you shortly then, and it's only gonna be on that one issue. And we're gonna get clarification on that for this time only. My interpreter will do her best, because I do want for that, because if it would have been from now, it's about a week and change. And if he would not be traveling from now until then I'd say that's a moot point, and we can just send you out to mediation. However, if he intends to continue traveling to Mexico, then we'll have a hearing on it. So
Yes, Your Honor. We will need, because there's a lot of things that need to be coming up about this, about the travel into Mexico, who's traveled into Mexico, who's traveled with the child into Mexico.
Yeah.
So
No, I understand.
definitely.
Okay, so I'll recall you shortly, and let me see how we're doing on the other ones as well, okay?
Yes, Your Honor. Thank you.
Okay, I'll call you right back. Okay. So F 2847-20-9, in the matter of the marriage of Ivan de la Mora versus Judith Ruiz Rodriguez.
Good morning,
Good
Your Honor.
morning, Ana Garza for Mr. Ivan de la Mora, Judge.
Good morning, Your Honor. Robert Mendoza for the movement on the one motion is pending. I did file another one for emergency hearing. I don't know if it got to the court's docket, but basically it's a supplemental of this motion here.
Okay.
Judge, and for the record, Catarina Alvarado, amicus for the child.
Okay, so then what do we have pending right now before the court?
Your Honor, we have the motion that I entitled motion to compel facilitation of the court's orders. In that motion, Your Honor, we're basically asking that we want this case to be over. We want to streamline this case just like the court wants to. The court ordered that admonished the parties to do what it ordered, and that was for my client to move to the Mercedes home and vacate the home in Corpus Christi so that the petitioner could go ahead and go in there. And that was done, Your Honor. The issue of connecting the utility water to the home, that is one of the big issues right now, Your Honor. The movement, the petitioner, Mr. De La Mora, even though he was admonished, he submitted an initial contract. It's a rental lease contract, which was already pre-filled out and ridiculous, to be honest, oppressive and selfish. Secondly, Your Honor, with regard to that lease, it's not necessary to have a lease on your own property. We could not, in good faith, have my client sign a lease to her own property where she becomes a tenant of Mr. Mora. It's very simple for Mr. Mora to either email an authorization or to authorize his wife, Judith Ruiz Rodriguez, to go ahead and connect the utilities. The issue that was brought up was accountability for the payments. That's not an issue. That's accountable for. The utility companies has accounting and billing and services, and we are ready to take care of those as they come along, or at the final hearing, whichever it is. But we're willing to pay them as they come along. Your Honor, it's been like 50 days, almost 2 months, since my clients have had to get water through a water hose from the neighbor to fill up cans of water to be able to bathe, to be able to flush the toilet, to be able to wash laundry in the washing machine. They have no way of getting any type of water. Now, these conditions have been there for the last 2 months, and the 4-year-old daughter is having to be part of this. I don't know what to name the situation other than unwise. And so we need for the court intervention to impose on Mr. De La Mora that this is a simple issue. He can go get the water connected, and then we deal with all the other repercussions or all the other details of payment. We have no problems paying monthly. But to subject my client to the willfulness and just capricious attitude of Mr. De La Mora through a contract that makes no sense, it's not something I believe that the court intended to do. That is one issue, and it's one of the major ones because it involves the sanitary conditions of the house. It involves the sanitary conditions of the bodies of the persons because they get to wash their bodies and the toilet. And we're asking first that the court order him to go out there and sign the contract so there can be water to the house. It's been 2 months. There's other issues. I don't know if the court wants me to address them now or address them as we go along.
Well, let me give Ms. Garza an opportunity to respond to that.
Thank you, Your Honor. Judge, if I may respond to that, Judge, your orders were that he had 24 hours to sign whatever he needed to sign. I think Mr. Mendoza received an email from his client on the 19th. On the 20th, we received an email on the connection of the water, Judge. We did some research. I did myself and my client did too. He called over there and he said there's 2 ways of doing it to connect the water. One, he would have to physically go all the way, take off from work, go over there and sign, and she would have to be there to sign that she wants it transferred to her name. That's one. The second way would be to just do a contract where her name is on there as a renter, and then she could connect the water. He did what they've done in the past, the same contract that they've done in the past with the same wording, which was, that she would be paying rent. And that was sent in. And then I told Mr. Mendoza, I said, here's a blank contract. Fill it in any way you want to and sign it. We'll get my client to sign it and we'll send it into the city. He says, no, because 90% of it or 98% of it does not affect anything having to do with my client. I said, okay, why don't you draw up your own? And you'll see the exhibits on there. There are exhibits as to the answer that I filed. I said, then draw up any contract you want yourself physically to say whatever it wants, whatever you wanted to say. We'll sign it and send it into the city. To this date, they've yet to respond, Judge. That's the problem. Their modus operandi is they don't respond, they ignore, they don't call back, they don't text back. They don't answer, Judge. We can't do anything more. She wants to be a victim, but she's not a victim. She's one of these very passive aggressive people. that acts like she's a victim, but in reality, she's creating the situation. She wants my client to come over here so he can be present and she can be present to sign it over to her. So then she can convince him to go back to her because she doesn't want a divorce. My client does not want anything to do with her, does not want to be around her. He wants a divorce already, Judge. She's just doing this so that he has to be here in person and she has an opportunity to try to convince him again a third time to go back with her because he's already done it twice, gone back to her, and now he does not want to go back to her.
Okay.
Judge, she needs to understand that.
Okay, no, not yet. Hold on.
All
Now
they
I'm
have
gonna
to
ask,
do is just drop their own contract, Judge. We signed it and it's done. And
okay,
apart from that, Judge, she has family here that she stays with, her mother and brothers and everybody that she stayed with here before. It cannot be that urgent if she's not doing, I mean, she preferred to come to court instead of draw up their own contract the way they wanted so we could transfer the water.
okay,
So, I
hold
mean,
on.
how logical is that?
Okay, hold on. Now I wanna, Ms. Alvarado, have you had an opportunity to visit the home?
Yes, Your Honor, I have. I went to visit with Ms. Ruiz Rodriguez and the child yesterday. The home was very clean and in good condition, but there is no running water in the home. Ms. Ruiz has done her best in having buckets and gallons and all kinds of things. And their neighbor has allowed them to use their water. So there is water to wash clothes and wash dishes and things of that nature, but it has to be brought in from a neighbor's home. But again, the home was very clean, considering that, you know, there is no running water. She did mention to me that they do sometimes go bathe at her family member's home, but that's where they're staying, that's where they sleep, that's where they eat. They're staying in the home. There's just no running water. So she does have, like I said, buckets and things in the bathrooms to flush toilets, to wash dishes, to wash clothing, things of that nature.
Okay,
So I did see all of that, Judge.
okay, so obviously you know that that's not a condition for a 4-year-old to be in at all. And so this thing about, and look, and I know how cities work, because even to get a permit for a business, it's so hard sometimes, and you've got to jump through their hoops. And so, you know, but it shouldn't have taken this long to try to figure out how to get running water into this home. Now, if they want a lease, if Mr. De La Mora honestly cannot get down here to do it on his own, and you know, it should bother him that his 4-year-old is having to bathe with a bucket. But if he can't get down here to do this because of his work schedule, then we have to come up with an alternative method. Now, if it's a matter of providing a contract, a rental contract, yes. Both of you understand that, you know, that under Texas law, spouses cannot enter into contracts technically. But the city probably doesn't care what the Texas law is, okay? If they're only gonna accept a contract, and Ms. Garza, from what I'm hearing, Mr. Mendoza is saying, draw up whatever you want and have them just sign for the purposes of this, for getting the water done. Are you not in agreement with that? Or what is your position for that? Mr. Mendoza.
Your Honor, well, first of all, this case has been over a year now, and Mr. De La Mora has found every way to somehow put an impediment and make selfish remarks, self-serving remarks, and has always impeded the progress of this divorce. And to subject my client to a contract where he is a landlord, that's number one. Number two, Ms. Garza is correct. We did exchange emails, but she didn't mention the conversations we had on the phone and the subject matters where we discussed. Number three is that when I spoke with the city, they said that a power of attorney or some kind of contractual authorization, not necessarily a contract. That's just what they told me, you know? And so I'm saying, why does my client have to be a tenant of her own property?
Okay, wait, okay, I understand that. I understand what you're saying, because as a principle of the matter, he wouldn't like it if she was making him the tenant. I get that. Okay.
Well, we don't want, we
But-
just,
Okay, but we have to get water in there. So he's not going to give her a power of attorney for any unless they're going to take a power of attorney for of a specific purpose.
exactly, Your Honor. Exactly.
Okay. Now, does it have to give her the power of attorney?
Actually, they didn't specify that and I didn't question it, Your Honor.
Because I mean, if you want to get to that, clients, I mean, he can give his attorney the power of attorney or whatever to act on his behalf. And only if Ms. Garza would want to go down there herself. I mean, that's a little above and beyond, which I think both of you have already gone above and beyond for your clients. You know, I'm just saying, like, look, yes. And to be fair, for a statement to be made that Mr. De La Mora has been doing things to impede the matters, it's both ways, okay? Because just being in front of me, there's been things that your client has done as well that has impeded the proceedings. So I can see both sides, all right? And yes, it has been going on for quite a while, but it hasn't been going on for quite a while in this court. And when in this court, we have come several times, and I've given you all the opportunity and the time that you needed in court, because I believe in not only you all having your day in court, but in trying to see how we can conclude these people's, this chapter in these people's lives so they can move on. Now, right now, we're fighting over a change in utility. In the meantime, whether you all like each other or don't like each other, you have your child that is having to bathe with a water hose and with buckets, and that's not right. One way or it's just not right. Whether you all like each other, don't like each other, I don't care. I only care about her. If you don't want to put your name on there as a tenant, if you don't want to put your name on there as a renter, if you want to put something on that thing saying it's not enforceable in any other way except for changing for the utility, the name on the utility, then so be it. Okay? But everyone has to put their pride aside so that we can get this done. It should not be this difficult. And I know that in our city, it's just a matter of taking a piece of paper to the other person to get signed, and that's it. I don't know. It's different in every city. It's different in every city. I don't know if they will allow for a like a Zoom conference or a FaceTime or something to have him come on. I mean, he's taking the time to come on to these proceedings out of work, you know, so it's better for him to take some time to go get that done so that we can try to conclude this. But if he really can't come down in person, we have to find another way. And I'm going to tell you all, I'm not going to use this time in court to try to figure out how to help you do this change in utility, because we have other things going on in here, guys. We have other things going on in here. No, Mr. Ruiz, you're not going to talk right now. Wait until your attorney says. So we're all in agreement that there's no running water in this house. And I think we're all in agreement that there needs to be running water in this house. So we need to come up with a way, and by we, I mean you all, need to come up with a way to get this running water in this home, okay? So I don't know how to make the city of Mercedes do that for you. I don't know what you all have to do, but you have to do something. Now that's one issue. Are we going to talk about anything else, or are we trying to get that issue resolved first?
Well, I can prepare a 1 or 2 liner where he authorizes the connections, Your Honor, and hopefully that will take care of it.
Okay. Ms. Garza already said they're going to sign whatever. It doesn't matter. So just send it over to her and they'll get that done.
As
Okay.
long as it has to do with the change of the utilities to her name for that house.
I agree. Just put specifically.
Judge, if I may, I know that you're not going to resolve this issue, but for me, it's very simple as an amicus for what's in the best interest of this child. Even if it's under Mr. De La Mora's name, who cares? This little girl needs water, and it should have been turned on immediately. And if they're all saying that this is for the child's best interest, even if it's in his name, then it should stay in his name, and she pays it. And then she doesn't pay it, then that becomes an issue for the court. But this child needs water. I mean, it's ridiculous that we're back and forth, and she's been in the home since June, and there's no water there. And for what? So that they can continue to fight and use their daughter as a pawn. I know that Mr. De La Mora has visited with the child in this last few weeks. So if he can make time to do that, he can come down and change the water, or he can leave it in his name. He did visit with her, Ms. Garza, and he doesn't have to see her. He can go to the city himself and just do it. And then once it's done, Ms. Garza can notify Mr. Mendoza, and then Ms. Ruiz can go and connect the water in her name. There doesn't have to be any communication. And that's what I see as a big problem here, is that the parties don't know how to communicate with one another.
Actually,
So
Judge, if I may respond, Judge, to what Ms. Alvarado is saying, my client has not seen his child at all in July. I have attached a couple of text messages where he asked to see the child on Friday night so he could pick her up the next morning on Saturday when he would be off. And she doesn't respond at all. She ignores all his text messages.
Judge, it's my understanding that Mr. De La Mora spent 4th of July weekend with his child.
That's correct.
Okay, Mr. De La Mora, did you see your child for 4th of July weekend?
Yes, I spent a few days with her.
Okay.
And
have
that's
you
because
been-
the child told me that too, Judge. She told me she popped fireworks with her daddy on 4th of July. So
Well, and the thing is though, is if your client, Mr. Mendoza, is not responding to his text messages, that's unacceptable. If there are text messages relating to visitation, that's unacceptable. It is. And
Judge, we do have another issue. My client gets
May I
very
finish my
irritated.
response?
well, I think
Does
Mr. Mendoza was gonna respond to that. So Mr. Mendoza.
Your Honor, the only text that Ms. Rodriguez did not respond to are where he goes up on a tangent talking about her, telling her to get the hell out of the house, stuff like that. Other than that, with response to the child, I submitted copies of those texts where she does respond to it.
Well, I'm seeing copies of text messages where more than 2 days go by and she's never responded. Where she's asking, why is her watch not charged? How am I supposed to call her if you always have it off? Why are you, I mean,
Those are self-fulfilling statements, Your Honor.
what I'm saying is that I know they don't like each other. And obviously they're not gonna be back together. And I just, they need to communicate though. And there can't be ignored text messages. And she can't have the child all to herself. She can't, because that's not gonna happen. They both deserve time with the child. They both deserve time with the child. And she has the majority of the time with the child because of his job. So when he has availability, the child should be made available to him. So you all need to come up with a visitation, possession, and access schedule that will allow him visitation according to his schedule. Because either he stays with this job and pays the child support that will sustain this child, or he goes and looks for a job that is not as sustainable and he's with the child whenever he wants. You can't have it both ways in a situation like this.
No quiere dar child support y él siempre se la pasa amenazándome, se la pasa atacándome.
No, Ms. Ruiz, we're not talking about that. Tell her that we're not discussing that right now.
5 minutos.
Ms. Ruiz, no estamos discutiendo eso ahorita.
Ahorita, okay.
Look, we just set it for a final hearing, Judge.
Well, the thing is that, have you all attended mediation?
Judge, there's no mediation to be had.
Yes, there is.
Judge, the last time we went to mediation, we proposed stuff to them, and if she'll just propose one thing, and if it isn't that, then she doesn't want to mediate it all,
No.
Judge.
That's not-
There's always room for mediation.
Judge, she won't mediate, Judge.
Yeah, I don't care what she wants or what they want. Hold on, Miss Alvarado, what?
Your Honor, I was able to visit with Ms. Ruiz and her child here at home, but I do want to talk to Mr. De La Mora and see when he has possession of his daughter so that I can visit with them. But it would have to be in Corpus because it's my understanding that that's where he's going to continue to reside. And so I do need to speak with him regarding that. And I did let Ms. Ruiz know that whenever he was available and I was available, she was going to have to release her daughter to him so that he could have visitation and I could do the visit over there, Judge. And the problem is that these parties, they just need a schedule, Judge. They need this child needs some sort of stability and a visitation. And I'll talk to Mr. De La Mora about the importance of, I know his job is very demanding and there's no set schedule, but maybe he can work out where it's 1 weekend a month since it's more than 100 miles away, and he can tell his boss ahead of time, hey, the third weekend of the month, I'm off because I need to pick up my daughter. Something that's consistent, because the back and forth, and I did read the text messages from the July 4th. So he picked her up and he was supposed to return her Sunday at 6. And then it came out and he said, hey, well, I'm off Monday. I want to keep her another day. Then, so they're continuing to change it even when they're agreeing to a visit. And it just doesn't work that way because they don't have a good relationship and their communication is not good.
Yeah.
Let's just be honest. Their communication is not good.
I understand that. Look, right now for my immediate concern is the water. Okay, that's my immediate concern. And I have, Mr. Mendoza, wait. And I have a lot of faith in both of y'all as attorneys and in the ad litem that you all will attend mediation in good faith, not be stubborn, not be, I can't tell you how many times I entered a mediation in 20 years where I said, this isn't going to settle. And then it settles. Because it also comes down to how much do you want this to end? How much do you want it? Mr. Mendoza, I'm not, okay, I'm not. And I've heard, right now, it's the water.
It's just that it's not true that we haven't gone to mediation. We went to mediation.
Okay, but we're gonna do it again.
Oh, okay, well, that's fine.
We're gonna do it again. And we're gonna go in with new attitudes. And we're gonna go in with a fresh perspective. And now you have an ad litem that is gonna be there as well, that can also assist in saying what is the best thing for this child. Because she's the only thing I care about.
I know.
She's the only thing I care about. So.
The only thing is, as an attorney, I don't like misrepresentations that we haven't gone to mediation and that we're not willing to go.
Okay, I get it. Don't worry about it. You forget that I was in y'all's shoes too, okay? And not very long. So not very long ago. Very long, yeah, it was a long 20 years almost. But anyway, what I'm saying is like, look, I get it, okay? And remember, I'm not a juror. I'm on the bench, and so I have a different perspective. So don't worry about it, okay?
La señora dijo que si mi niña se moría, la mediadora, que si eso no importaba.
Okay, I'm not gonna do that. Mr. Mendoza, I'm gonna talk to your client. I'm gonna keep muting her, and if she doesn't, then I'm gonna remove her, okay?
That's fine.
Look, my first thing is work to get that water on. I want that water on as soon as possible. I cannot say within 24 hours or 48 hours, because then my order is not going to hold over to the city. You just know how fast I want it done. I want it done like yesterday. Number one. Number two, you all will be attending mediation. I will send out an order of referral for the mediator, because you need to go to mediation and you need to finalize this, and this needs to get done. And it needs to get done with somebody that will be thinking outside of the box and will also be able to assist you with some client control if necessary, okay? I'm gonna be very blunt about that. Now, what we're gonna do is, as soon as that water's turned on, please notify the ad litem. The ad litem will notify my staff. And then we'll go ahead and have you mediate this case within 30 days. An order of referral will go out by the end of the week so that we can have you start working with getting those dates. And then I want you all to come back and give me, I'm not gonna say a final hearing, but I want a status on August the 25th at 11 a.m. If by some chance you've already mediated by then and have finalized it, then we can do a prove up. Okay? Now, Mr. Mendoza,
Yes,
please
Your Honor.
have, I know your client is very emotional right now. And she probably feels like she hasn't been heard, but she's been heard. And this is the way, this is my order of the court. And Mr. De La Mora, I know that you feel that you've exhausted your patience by this point, but just hang on a little bit longer, okay? Everybody hang on a little bit longer. That's all, okay? We're almost there. And if I'm not ready to give up on this, then I'm not gonna let you be ready to give up on this yet, okay? So we'll go ahead and return for a status on August the 25th at 11 a.m. within which time you'll mediate it within before now and then, and I'll have an order sent out to you by the end of the week. Please let the ad litem know when that water is reconnected, okay?
Nomás lo están dejando que me maltrate y que me insulte. Y que
Here we go
mi
again.
hija vea todo.
Okay.
Thank you.
I'm gonna consider her outburst. If she does an outburst one more time, I'm gonna hold her in contempt. I understand, but I've given her lots of time to talk in the previous hearings, and I know what she's gonna say, and I understand it. Okay, but just tell her to be patient. And I'm not allowing anybody to insult anybody, and I'm not letting anybody to disrespect anybody. Right now, what I want is that little girl to have running water as soon as possible, okay?
Thank you. May I be excused, Your Honor?
Thank you,
Yes,
Judge.
everyone is excused.
Thank you.
Thank you. Okay, F
Thank you, Judge.
2686-21-9 in the matter of the marriage of Lisa Rodriguez versus Saul Salinas. Do I have anyone here from Sergio Sanchez and Frank Guerra's office?
Good morning, Your Honor. Yes, Frank Guerra, Judge, on behalf of the respondent, Saul Salinas.
Okay, sir. And were you making an announcement on behalf of Mr. Sanchez as well, or?
No, unfortunately not, Your Honor. His office did send over a counter proposal for a possible final decree. However, there are issues that I think will not be able to be agreed on. So we're kindly asking for some kind of hearing.
Okay, so I have you set for a status conference hearing or a final hearing, whichever, so you were not able to finalize this matter.
No, Your Honor.
Okay, so have you all attended mediation?
No, Judge, we haven't.
Okay, so then, hold on. Are there children involved?
Yes, Your Honor, 3.
Okay, what are the ages?
Mr. Salinas is present. He could testify to that.
Okay, English or Spanish?
He's an English speaker. Mr. Salinas, can you put yourself on mute? If not, I can walk over there and help you.
Just go ahead and press the microphone, Mr. Salinas, on the screen.
On there. I'm here now.
Okay, sir. So, how old are your children?
Austin, he's 11. Sean, he's 5. Ethan, he's 2.
Okay. Now, Mr. Guerra, what are the issues in this matter?
Issues include child support amount. Mr. Salinas is currently unemployed.
Okay.
As well as visitation schedule.
Okay, one moment. Ms. Rodriguez, Lisa Rodriguez, I know that you're present, ma'am. Can you turn on your camera and unmute yourself?
Yes, ma'am.
Okay, thank you. Have you had any contact with your attorney, ma'am?
No, I talked to his paralegal this morning, but I haven't talked to him since.
Okay. Now, Okay, so they're telling me that child support, visitation, possession, and access are all at issue at this time.
Yes.
Okay, well, that's the normal things that are gonna be at issue. So, I mean, we haven't made any progress then from the time that you all filed this. When did you guys file this? When was it filed, Mr. Guerra? If you can assist the court.
I can, Your Honor. It was the petitioner that filed, I believe it was back in February. I'd have to check with the docket just to make sure, Judge.
Okay, did you file a counter petition?
No, Your Honor, we didn't.
Okay,
Just an answer.
will you be filing a counter?
No, Judge.
Okay, all right. So then, child support, child support's gonna be what it is. It's a numbers game. That's it. It's gonna be what it is unless y'all don't agree in the fact that whether he's not working where he's working or if he's not being truthful, that's something else, okay, if you believe that. Visitation, possession, and access, it's very easy. It's standard. That's gonna be standard unless he elects extended standard or you all come up with a customized possession order. I mean, it is what it is. Or you can prove that he is not, doesn't merit standard for whatever reason, okay? And I'll entertain that. But in the meantime, if y'all have not attended mediation, mediation is always required in this court prior to any final hearing. So you will be required to go to mediation. I will have an order of referral sent to both of you all by the end of the week. And we're gonna go ahead, I'm gonna put the referral. Are you gonna want me to put the referral for temp orders or for final?
I think final would be.
Okay, so I'm gonna do the referral order for final. And then we're gonna go ahead and have you guys attend that within the next 30 days. And then I'm gonna have y'all come back for a status hearing on August the 25th.
Yes, Judge.
Okay. If you're gonna need a contested hearing, it'll be August the 25th at 9:30. If you're gonna need a contested hearing because you didn't settle, you need to get with my court coordinator so that she can give you another date.
We will do that, Judge.
And then at that time, you can let her know if you're gonna want a bench trial or a jury trial.
Yes, Judge.
But it's just possession, access, and visitation. I mean, visitation, possession, access, and child support. I mean, those are not jury issues, so.
Yes, Judge. Okay. That is all the business I have. May I be dismissed, Judge?
Yes, and so Ms. Rodriguez, you can let your attorney know that you all are gonna be ordered to mediation.
Okay.
And you're gonna return here on August the 25th at 9:30.
Okay, I'll let him know.
Okay, thank you, ma'am. Y'all have a great day.
You too.
Thank you.
Okay. Hold on, I have somebody trying to get in. Okay, F 3266-21-9 in the matter of the marriage of Jose Andrade versus Jerry Andrade.
Good morning, Judge. Fabian Guerrero here with Mr. Andrade, Jose Alberto Andrade. We had filed TRO and we just need an extension because we haven't had a chance to serve the wife. The wife is what state was it? Colorado. And she's in Colorado right now. The child obviously resides in this state and resides in this county prior to filing the suit to.
Where's the child?
With my client, living with my client. So we wanted a 14-day extension to try to get her served up there in Colorado. We were expecting that she was going to come down to the valley and serve her here, but that doesn't seem to be the case anymore. So now we've got to go find somebody to go serve it up there in Colorado.
Okay, and she's and the child is how old again? Remind me, 15? Or
The child's 5 years old, born in 2006. Right?
no, 15.
16, I'm sorry, 16, I'm sorry, 16, my
I was
bad.
gonna say, I remember seeing a 2005 or 2006 on that. Because I do read the affidavits and the petitions just in
Yes,
case.
I was told as much, yes, thank you, Judge.
You were well advised.
Well advised, yeah, and, you know, you scrutinize, you shouldn't say read, you peruse it, because you pretty much catch all the errors. Okay, go fix this, guys.
Well, I tried. So, all right, your request for the extension will be granted.
Okay, thank you, Your Honor. We'll send an order.
Okay, hold on. Well, she's on.
Oh, she is?
Yeah, Miss Andrade.
Okay, good.
Okay, so Miss Andrade, you have not been served yet physically with a document. Is that correct?
That is correct, yes.
Okay, so you are entitled to service with that with that document so that you know exactly what it is that you're what the pleadings are. So
Okay.
do you want that emailed to you and include that as service, or did you want someone to physically get that TRO and petition to you?
I prefer physically so I can have the affidavit and everything on paper, so I can potentially hire an attorney.
If they email it to you, they have to include the affidavit. But if you want it to be personal service, you have that right as well.
Yeah, I prefer personal. That way it gives me time to focus on getting an attorney.
Can she reach out? I mean, I don't want her to do it right now because it's a public forum, but if she can give us an address in Colorado, I'd be happy to make sure the process server goes out there.
I did give an address to Jose.
Okay, good. We'll use that address then.
Does Mr. Andrade, did you receive that address?
Yes, I received that on Sunday.
Okay, pass that address along to Mr. Guerrero. Ms. Andrade stating on the record that that is an accurate address where she can be served.
Okay.
And then, so Ms. Andrade, usually what a civil process server will do is contact you to make arrangements so that you can meet them. So I'm gonna take you at good faith that you're gonna make those arrangements with that person and not try to avoid service.
No, they did actually reach out to me yesterday, and he was actually going to send it through the mail certified.
Okay,
and
that's
I was gonna
another
go
option.
sign for it.
That is another option as well, that they can have the clerk's office send it to you certified mail. If you do certified mail, Mr. Guerrero, just please make sure you specify restricted delivery, because it is not a good service unless that green card is signed by the respondent. Okay? Now, your extension needs to be filed as soon as possible. And then we'll have another setting on that extension.
Fair enough,
Okay.
Judge.
So I would get that done as soon as possible, especially if you do end up sending it certified mail, which is also considered personal service. Then you're gonna need that citation as soon as possible as well.
We'll do that, Judge.
Okay, Ms. Andrade, I appreciate you coming on, and Mr. Andrade, make sure you give that information to Mr. Guerrero.
I will, Your Honor.
Okay?
Thank you.
Okay, y'all have a great day.
Thank
you.
Judge, I'm sorry to interrupt. Before you move on ours, the ad litem is not, I wasn't included in the order, so he's not signed on.
You all have an ad litem?
No, on mine, Judge, just on, yes.
No, I'm asking you. On yours, you have an ad litem?
Yes, it's, Your Honor, I was on this case prior, then Ms. Klein was on, and I was co-counsel, now I'm back as main counsel, so it's Rick Flores is my understanding. And I just wanted to let the court know, because I don't know if that you want him to be signed on. Ms. Valdez did reach out to him, and it's her understanding that he's not available at the time because he's not in office.
Okay, hold on. Okay, Mr. Andrade and Ms. Andrade, you all are excused. So we'll just get that. Okay, so y'all have a great day.
Thank you.
Okay, yes, ad litems are supposed to be included in all the hearings.
Yes, Your Honor.
I don't know.
I
Ms.
asked your
Williams?
staff, and it was, I guess I had not put him on the order, and that's what happened.
Oh, okay, I didn't even know you had an ad litem, to be honest with you, because like I said, I don't have access to my fried laptop right now.
And I apologize to Ms. Williamson as well. I guess I didn't I didn't see that I hadn't included his email.
Okay. The only thing is that I'm just concerned about that. I want to hear, like, what I'm guessing is that you're saying you don't want international travel, and I'm kind of putting together that Miss Williamson's gonna say, well, why doesn't she want international travel if she traveled to Mexico with a child or something like that?
That's exactly it. That's the
Okay.
whole crutch of our argument, Your Honor.
Okay, so I'm gonna.
And before my client says anything, she's trying to talk. We're denying that allegation that she ever went to Mexico. So that's,
Okay.
but Elda, you don't have, go ahead and mute yourself, okay?
Okay,
Okay, Your
I
Honor. Well,
understand that.
We're prepared with records where, I mean, she's had surgeries in Mexico. She has been there with the child to Mexico.
I have never taken my child to Mexico. I've been myself for medical reasons, but I've never taken my child. Every time she leaves Hidalgo County, I notify him via text or via phone call. I've never ever taken her because I have no reason to take her. Not like him that he took her without even notifying me.
Elda, thank you.
Okay,
Just mute you.
so I understand that, but since there's an ad litem on this matter, I mean, and I would normally put both of you on their oath, and then you can say that, and then he's gonna say whatever he's gonna say. But so Mr. Flores is not available today, right now?
That's my understanding, Your Honor. I don't know if.
Well, okay, what I'm gonna do is I can excuse you temporarily and see when Mr. Flores is available.
Okay.
See if he's available at all anytime this afternoon.
Okay.
And if he is available this afternoon, let us know. And if he's not available this afternoon, then when's the fastest that he can be available, even if it's Friday afternoon?
Yes, Your Honor.
Which I don't know if he'll be available.
Yeah,
but look, just get the dates that he's available like ASAP, okay?
Yes, sir.
Because I understand both of your concerns, both your clients and Ms. Williamson's clients' concerns.
Yes,
So,
Your Honor. I'll go ahead and do that.
And it could very well be that the ad litem's just gonna say like, Judge, I haven't even met with anybody in a long time, so unless he,
Your Honor, and I'm gonna tell you, as far as my client, he hasn't been in contact with my client or with the child with my client since 2017.
Okay, so, but unless he gives you all permission to move forward without him here, then he's supposed to be here. He's entitled to the notice and supposed to be here. So you all can even ask him that, say, or do you not want to be at the hearing?
Okay.
You know what I mean? Whatever, but he would have to waive that on his own. You know what I mean?
Yes.
So you guys talk to him, and if he does want to be present, then we'll work around his schedule, and I'll work around my schedule to make something work. Okay, so I can temporarily excuse you until we still have a few more things on the docket, and then you all can come back. Somebody come back on and let us know what we're gonna do.
Yes, Your Honor.
Okay.
Thank
Well,
you.
we'll stay, Your Honor, because we don't know when she's gonna call or not call, so we'll stay.
That's fine.
Thank
Okay.
you, Your Honor.
Thank you. Okay, CL 163265-I, No Chantu versus Kevin Ho.
Your Honor, if I may.
Miss Ramirez is trying to unmute herself. Okay, well, while she's figuring, oh, there she is. Ms. Ramirez, can you hear me?
Yes, I can, Your Honor.
Okay, I was just about to take an announcement from my court coordinator. Okay, Ms. Rivera?
Yes, ma'am. Judge, Miss Palacios' office just emailed me. They didn't receive the link for whatever reason. I have sent it to them, so she should be logging on shortly, I believe.
Okay, so we're just, Ms. Ramirez, did you get that screen sharing fixed?
Yes, Your Honor, I believe so. I hope so.
Okay, so then we'll pick up with your motion for summary judgment just momentarily, okay?
Yes, Your Honor.
Okay. Okay, and then P 0312-20-9 Nicolasa Villarreal versus Abraham Dietz.
Good morning, Your
Morning,
Honor. Alex
Judge.
Lefta on behalf of the state and the applicant.
Good morning, Judge. Jaime Cavazos here on behalf of the respondent.
Good morning. Okay, so what are we doing today?
My understanding, go ahead.
Go ahead, I'm sorry. I do see the respondent and the applicant are both present, but the respondent's screen is turned off.
Mr. Dietz, can you hear me? And is it Diaz or Dietz?
Yes.
Yes.
Okay, Mr. Diaz, I need for you to please turn your camera on, sir. Okay, take off your glasses and your bandana. Okay, thank you. Okay, and you may proceed.
Judge, on this case, Mr. Cavazos and I conferred yesterday. I believe we do have an agreement. So if we can swear the applicant in, and I'll read the agreement on the record and ask for a couple questions about that.
Okay, Ms. Villarreal and Mr. Diaz, can you please raise your right hand? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Ms. Villarreal?
Yes, ma'am.
Okay, Mr. Diaz?
Yes, ma'am.
Okay, you may lower your hand. Okay, Ms. Huerta, you may proceed.
Thank you, Judge. As I noted, the parties have conferred and have come to an agreement in this matter. We're asking the court to find that the relationship is that of the biological parents of a child, as well as a former dating relationship. We are asking the court to grant a protective order without findings, that any orders regarding the minor children will be pursuant to any orders that take place in F-4922-19-9. And that goes for conservatorship, visitation, child support, anything pertaining to the children or to the child. There is no property to be divided. We are asking that the court prohibit him from committing acts of family violence, directly or indirectly communicating in a threatening or harassing manner with the applicant or a member of her family or household, communicating in any manner with the applicant or member of her family or household, unless appointed by the court, specifically any attorneys that would be handling the custody case, the SAPSR case, from engaging in conduct that's likely to harass, annoy, alarm, abuse, torment, or embarrass that person, harming, threatening, or interfering with the care, custody, or control of a pet, companion animal, or assistance animal, from going within 200 yards of the applicant's household, her residence, her school, or her place of employment, and from possessing a firearm. If he has a license to carry, we ask that it be suspended and that he be ordered to surrender any firearms and ammunition to the Hidalgo County Sheriff's Office within 10 days of the signing of this order. We further ask that the court costs be waived and the protective order be in full force and effect until the 21st day of July 2023, so a 2-year protective order. Ms. Nicolasa Villarreal, can you please state your full name for the record?
Nicolasa Villarreal.
And you and I have discussed this protective order at length, is that correct?
Yes, ma'am.
And what I just read onto the record, that is your understanding and your agreement?
Yes, ma'am.
And no one is coercing you or forcing you to agree to this, is that right?
No, ma'am.
I got a double negative there. Let me correct that statement. Is anyone forcing you to agree to this protective order?
No, ma'am.
I have no further questions from the applicant, Your Honor.
Okay, do you have any questions, Mr. Cavazos, of the applicant?
Yes, Ms. Nicolasa, you are the parent of 2 children, is that correct?
I am the parent of one of his child.
I understand, but you have 2 children, right? Or do you have more than 2?
No, I have more than 2.
Okay, so you have 2 children. One of them is Lorraine Guadalupe Diaz Varrial.
Which is not his daughter.
But has his name, right? Is that correct?
Yes.
Yes, but it's not his daughter, and we found that out through DNA, right? Is that correct?
Yes, that is correct. He knew the whole entire time.
Okay. And then Bea Mia Varrial doesn't have his name, but is his daughter?
Yes.
Is that correct?
Yes, he was not present there. He was having a conflict with me and harassing me at the time, and I told him to stay away for the distress of my pregnancy.
Mr. Cavazos, you may want to just stick to whether or not she's in agreement with the agreement as it was read into the record, or you might be opening the door to some other issue.
I understand, Judge. I just wanted to make sure that it was Nicolasa that we were speaking with. We've never seen her. I've never met her. I know. Ms. Nicolasa, you understand the protective order that's in place, right?
Yes, I do.
And you're in agreement with that?
Yes, I am.
Yes, that's all I have, Your Honor.
Okay. All right, then the court will accept the agreement as read into the record by Ms. Huerta. And we'll accept the terms. Yes, ma'am.
Is Mr. Cavazos going to be asking Mr. Diaz if he was in agreement? Because he has not signed the order. May I or Mr. Cavazos ask him to put that on the record?
Yes, either one can ask him.
Mr. Diaz?
Yes, sir.
Good morning. We discussed this several times, right? As far as the protective order?
Yes.
And you understand and I know you haven't signed it, but you understand the restriction they're placing on you as far as the mom, as far as Nicolasa?
Yes.
And you understand these restrictions have nothing to do with your child that you all have together?
Right, yes.
Yeah. And you're in agreement with the restrictions and the protective order?
Yes.
Okay. That's all I have, Your Honor.
Okay. Then the court will still accept the agreement as read into the record. Okay, so what are we doing on the companion case on the F492219-9? Is that's a SAPSR?
Yes, Your Honor. Ms. Huerta is not on that case, of course. That was an original case that was filed in 2019. Ms. Nicolasa was served. I believe she was living in Houston at the time. After some time, they reconciled and lived together for a while, and then they separated. And that time is when my client had wanted to proceed with the SAPSR. We had an issue trying to get the DNA results. We actually got them in March of 2021. I filed those with the court, and we're going to ask to challenge the acknowledgement of paternity on the oldest child, and then we're going to ask that the youngest child, that is his child, that he be acknowledged and adjudicated as the father, and that there's a name change. The original petition included it. We included, to be honest, Your Honor, for the youngest child. It kind of worked out the other way around. We haven't been able to.
I understand that, but what I'm saying is what's concerning me is that there's no visitation in place right now at all.
Yes,
And
Judge,
so my concern is that, one, if there's going to be an agreement as to how he's going to be able to see the children, of course, I want to know when he's going to start seeing the children. And if there's not an agreement right now, I don't want this thing of, I'm picking up the child and then not taking the child back. You know what I mean? So that always concerns me. So were you going to be filing for temp orders for me to hear something? Because that's not being taken care of in today's proceedings. The only thing I'm taking care of today is the terms of the protective order. So now we need to take care of possession, visitation, and access.
Yeah, I don't know. We haven't obviously spoken with mom. I don't know if mom has an attorney or she's going to get an attorney. At this point, we're trying to get at least standard visitation for, I believe the last we heard, she was out of the county. So I believe it's over 100 miles. I'm not real sure. We don't know where she lives. But we were trying to get some visitations for him on the minor child, on Bea.
Okay, so Mom, Ms. Villarreal, are you going to be hiring an attorney?
Yes, I am.
Okay, so, and do you know what time frame you're going to be hiring that attorney?
I am supposed to be getting a response this week, so that's all I am waiting for. They had to look over the whole incident and the application, so I am literally supposed to get a call this week. After I'm done here, I'm going to call to check up on that application.
Okay, so as far as the protective order is concerned for today's matter, I'm going to wait for that'll be circulated for your signatures, and then that'll be submitted to me, and then I'll sign off on it. Okay. Now, as for F4922-19-9, I'm setting you for a status hearing on August the 25th at 9:30. So that I want to see at that point if you've hired an attorney and where we are as far as what we're going to do for visitation, possession, and access.
Okay.
Okay.
Yes, ma'am.
Judge, can we get any type of visitation for Dad in the meantime?
I'm not gonna do that right now because that's not before me.
Okay.
You all said you're taking care of that on F 492219-9. So if you want anything, I would suggest filing that motion for temp orders to see if I can hear it between now and the 25th. You can do, but I'm gonna tell you, we are stacked. I'm making some room for you all on that day, but August is crazy already stacked.
Mm-hmm.
So, but I mean, you certainly can file your motion and I'll do my best to accommodate and give you some time.
Okay, Judge, we did file the motion to challenge the acknowledgement of paternity, and maybe we can set that at the same time.
Okay, do you have an order setting hearing for that?
Yes,
Okay,
it should be in the court queue.
if you, then we'll go ahead and make a notation of that so that we can look for it at the clerk.
Your Honor, I have a question about that. What is to challenge with the paternity test? What is that?
What they're saying is, well, I haven't read the motion, but it's pertaining to his paternity. So you're challenging it on which child, Mr. Cavazos?
On the oldest child that has his legal name and he's on the
Okay.
birth certificate.
So he's on the birth certificate of that child?
Yes, Your Honor.
Yes.
Okay, and then, well, all the arguments I'll wait to hear for that time because he only has a certain time period before he can challenge that. So, but okay, so for today's purposes, I'm gonna wait for that protective order to be sent to my queue and I'll sign off on it. And then on the companion case, we'll see you on August the 25th at 9:30 for a status.
Okay.
Judge, if I may,
Yes.
regarding the protective order, did you want us to submit that or did you want us to circulate it to the parties for signatures? since all
Circulate
parties
for-
are present?
Circulate for signatures anyway.
Okay. Understood.
Okay,
Thank you.
because it has happened before where all of a sudden they have amnesia and then they don't remember what they testified to.
Understood, Judge, yes.
Okay, and now that they're both present, I'm gonna tell them that your signature is required, so don't be avoiding the actual order, because just because you don't sign it doesn't mean I won't sign it. All they have to do is try to get your signature. If you avoid them to sign it, they can just file a motion for entry or submit it with their signatures, and I'm good enough with that, okay? So if it becomes too difficult, you just submit it and I'll sign off on it,
Understood, Judge, thank you.
okay?
Good, Judge.
All right,
We have
That's
no
all I
further business. Oh, go ahead, Mr. Cavazos.
May we be excused, Judge?
you certainly may.
Us as well, Your Honor.
Yes, ma'am.
Thank
Y'all
you.
have a good day.
Likewise, thank you.
Ms. Villarreal, Mr. Diaz, you all are also excused.
Thank you, Your Honor. Have a wonderful day.
Thank you, likewise. Mhm. Okay, Ms. Gonzalez?
Hi, Judge. I
Good
have,
morning.
good morning, an agreed prove up. I hadn't been able to see the respondent, and I think she finally logged in. I just wanted to.
Okay, yeah, I'll recall the case now, F 2456-20-9, Jose de Jesus Carizales versus Belinda de Jesus Coronado. Ms. Coronado and Mr. Carizales, please
Yes,
turn on your
we
cameras.
do have an agreement.
Ms. Coronado, can you turn on your camera, please? Okay, and can both of you please unmute yourselves? Mr. Carizales, can you unmute yourself? Just, okay. Ms. Gonzalez, I have you also trying to come in again.
Yes, Judge, my laptop just started acting funky, of course, as soon as I requested it. So I'm just gonna hop on like the desktop.
Okay.
There we go.
Okay. Let me have Mr. Carizales and Ms. Coronado, please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Mr. Carizales?
Please.
I can't hear you.
Judge, they're both Spanish speakers. I'm not sure if the
Oh,
translation is
I'm
going
sorry.
separately.
Okay, Ms. Castañeda, can you please ask them?
Yes, ma'am, go ahead.
Can you please translate the swearing in to them?
Yes, ma'am. Por favor, levanten su mano derecha. Que juran que el testimonio que están a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Sí.
Yes.
Okay, Mr. Carrizales says yes. Ms. Coronado?
Sí.
Sí.
Yes.
Okay, please have them lower their hands.
Pueden bajar su mano.
Okay, Ms. Gonzalez, are you going to read the agreement into the record?
Yes, Judge.
Just go slow and in part so that she can translate it.
Yes, ma'am, will do. Judge, the agreement is that the parties will be named joint managing conservators over both children, Jesus and Ariani.
El acuerdo, Mr. Rivera, es que los dos van a ser managing conservadores juntos de Jesús y Ariani.
Jesus will reside primarily with Mr. Carrizales.
Jesús va a vivir con el señor Jesús Carrizales.
And Ariani will live primarily with Belinda Carrizales.
Y Ariani va a vivir primeramente con Belinda Coronado.
Yes, and my client, Mr. Carrizales, will continue to pay $100 weekly at a maximum of $400 a month to the mother for the support of Ariani.
Mr. Carrizales va a continuar a pagar $100 por semana, de máximo 400 por mes, a la mamá por el cuidado, por la niña de Ariani.
Mother will be named as primary managing conservator for the purposes of insurance and will continue both children on Medicaid.
La mamá va a seguir continuando a ser la primera custodia de los niños de Ariani y para ponerlos en el aseguro por cosas del aseguro.
Yes. We will calculate the medical support, Judge, according to the OAG guidelines. At this time, I do not have that before the court. However, the parties have agreed to split that.
Vamos a calcular lo que es el aseguro, por ahorita no tenemos la cantidad.
Okay. The children will alternate weekends so that they can spend time together.
Los niños se van a tener visitas alternativas para pasar el tiempo juntos.
Okay. And we will alternate holidays and summers according to the Texas Family Code.
Y vamos a tener alternativas también para visitas de cómo va en el código de la familia.
Okay. With regards to community property, there is none. Each will keep the items in their respective possession at this time.
A este tiempo no hay propiedad de la comunidad. Cada quien se va a quedar con sus propias cosas.
Okay. Each will keep whatever vehicle is in their possession, along with any debt associated.
Cada quien se va a quedar con su mueble que tienen, su carro, también con la deuda que pertenece.
Okay. And let me just confirm over here. Each is responsible for any debts in their sole name from the date of divorce, which is, I'm sorry, from the date of separation, July 13, 2020.
Cada quien se va a quedar con sus propias deudas desde el día del separo, que fue julio 13 del 2020.
Okay. At this time, Ms. Carrizales is not expecting a child of the marriage or is not pregnant.
A este tiempo, Ms. Carrizales no está esperando bebé ni está embarazada de este matrimonio.
Okay. And I believe that covers it. It's an agreement, Judge, to proceed with a no fault divorce under insupportability.
Vamos a proceder con un divorcio sin culpa por irreconciliables deudas. Agrios.
Okay. And one item that I misjudged with regards to the children, the parties have agreed that Jesus, the minor child, will be raised pursuant to the Jehovah Witness faith, and that he will not participate in religious services while at mother's home.
Okay, los papás están de acuerdo que el niño va a estar de acuerdo a participar en los testigos de Jehová.
I believe that covers everything, Judge, with regards to conservatorship support, medical support, and the community property division.
Okay. Ms. Castaneda, can you please just ask each one if they understand the agreement as it was read into the record?
Mr. Carrizales y Ms. Carrizales, ustedes los dos entendieron este acuerdo que acabamos de presentar frente a la corte.
Sí.
Yes.
And Ms. Coronado?
Sí.
Yes.
Okay. And can you ask them if they feel that that is a fair and equitable, I guess, a fair and equitable, because they don't have any property, right, Ms. Gonzalez? You stated?
That's correct, Judge.
Okay. So, or are they asking me to accept the terms of the agreement?
Okay, los dos están de acuerdo a que la juez acepte los términos de esta divorcio.
Sí.
Yes.
Judge, I do have one. Oh, I'm sorry.
Sí.
Yes.
I noticed her name is Coronado on the screen, Judge. When we filed it under Carrizales. I just need to confirm whether she's requesting a name change and if in fact it is to Coronado.
Ms. Coronado, ¿usted está pidiendo que la corte le cambie su nombre de Carrizales a Coronado?
Nunca me lo he cambiado.
I never changed it.
Okay, then I'll amend it, Judge, so that it reads Coronado for her signature.
Well, the style of the case has Coronado on my docket.
Okay. Huh. Maybe it's something on my
You
end.
may have surprised yourself like I do sometimes.
Happens on the daily basis, Judge.
Okay. All right, and nothing further than the court will wait for the divorce decree signed by both parties where we'll have more detail. Okay?
Thank you. Judge, and if we could just admonish Ms. Coronado to sign off on that since she is pro se.
Okay, yes, Ms. Castaneda, please let Ms. Coronado know that she has to sign that divorce decree.
Ms. Coronado, usted tiene que firmar el decreto del divorcio.
Okay.
Okay.
And Ms. Gonzalez, after a good faith effort and the attempts to try to get her to sign, if she doesn't sign, just go ahead and submit it for signature with just yourself and your clients, and I'll still sign off on it.
Perfect. Thank you so much, Judge. May we be excused?
You certainly may.
Thank you. Bye-bye.
Okay. All right. You can let Mr. Carrizales know and Ms. Coronado know that they are also excused.
Mr. Carrizales y Ms. Coronado se pueden retirar.
Okay, gracias.
Thank you.
Okay. I see that Mr. Flores is on. And Mr. Flores, I'm gonna recall F0981-15-9. And apologize, sir, I was not aware that you were an ad litem on that case. So.
Yes, hi, good morning, everybody. I was called by my paralegal. I was on my way over here to begin with, so I was trying to catch up in the interim that I logged on as far as to the issues there before the court. Been a lingering case, and I see that I guess it's Ms. De Luna filed a motion to modify temporary orders, but maybe the court can, or they can fill me in as far as to what the issues are right now.
Well, there's several issues, but the one that's concerning today for both parties is international travel for the child. And so that's the only issue that is, I guess, pressing for this point, because we are going to need either a contested hearing but it would be after they go to mediation.
Judge,
And Judge,
I'm sorry.
I'm sorry, Judge. I think we might have come to a resolution, kind of easing both sides.
Judge, what we're trying to do, Ms. Williamson, is because of the length of the case, how long this has gone on, in speaking to Ms. Williamson, I do think that we may be able to come to some agreement in mediation or get a lot closer than they had before. The Mexico issue is still a very pressing issue for my client, but I was able to speak to her and kind of come to some agreement that maybe that's something we can bring up in a final, if necessary, hearing to resolve that issue from here on out. The understanding was that Mr. Cifuentes was going to go to Mexico again. However, I believe our agreement is that after this week, he no longer was going to go to Mexico until we can come to some resolution, either by mediation or by the court. To ease my client's issue with that, with the daughter being in Mexico, is that they were going to facilitate a daily call, video conference between the hours of 7:30 and 8:30. And if Mr. Cifuentes, for some reason, misses her car, is unable, or their daughter doesn't, is asleep, or something happens at that time, he is to return that phone call within 1 hour or get his daughter to communicate again with Ms. Valdez. It doesn't resolve the issue, as far as that's still going to be something that's going to be a contested hot topic, I guess you could say. But in order to try to kind of facilitate us working towards something, I did speak to Ms. Valdez. As you can tell, she's very emotional. But as to this being the last week that he'd be allowed to go to Mexico until we're able to bring it back up with the court.
Okay.
Ms. Williamson can agree, or I don't know if that.
I believe, Ms. De Luna, we forgot one thing, that if the father comes back from Mexico, the child's to come back with him, not left in Mexico if he were to come back. It has not occurred, but he will not leave the child in Mexico. Once his summer is over, his summer vacation this month, then there will be no more travel to Mexico until it's addressed with the court, Your Honor.
Okay, so how old is the child?
7.
7.
Okay, that's a very tender age. That's a very tender age. And okay, so I'm not going to entertain any arguments at this point as to whether who's gone, hasn't gone. But what I am going to say is, whether it's in Mexico or whether it's in the United States, if this child receives medical treatment, the parents are both to know. Ms. Castaneda, can you translate that to Mr. Cifuentes?
He understood that, Your Honor.
Okay. Okay. So that is very crucial. So, Mr. Cifuentes, I'm not saying that your daughter did see a medical facility in Mexico under your care, but I am saying that if she did, I fully expect that you will give that information to your attorney so that can be passed on to Ms. De Luna and to Ms. Valdez. Okay. Both of you have been on to hear me on a previous hearing, and I'm going to reiterate. My only concern is that 7-year-old child. Not whether you all like each other, not whether you all are going to reconcile, only that 7-year-old child. And like I said previously, I fully believe that the child does need time with mom and does need time with dad. And when it's your visits, it's your visits. And international travel is always going to be a very touchy subject, always. So I commend you all on coming up with a temporary agreement. I will give you 2 choices. You can either put that in the form of an order, or you can put that in the form of a Rule 11 agreement. I have confidence in both of you all and in the ad litem and in your abilities, your professional abilities, that you all will respect a Rule 11 agreement just like you would respect an order. The Rule 11 agreement obviously is faster than to get a signature from me, but whatever you all want to do. I am going to order you to mediation within 30 days. A order of referral for mediation will be sent to you by the end of the week, okay?
And can this court give us a final hearing, Your Honor?
I
Or
certainly
DCC,
can.
whatever.
Okay, so I'm only giving DCCs for bench trials. Why don't we do this? Since I'm gonna order you all to mediate within 30 days, I'm gonna have you all come back on September the 1st. At 9:30, I'm gonna set you as a status. If for some reason you have settled, you can prove it up at that time. If you have not settled and your report that day will be that you're asking for a DCC date, I will give you for a bench trial. But if it's not for a bench trial and you will need a jury trial setting, then, I mean, we're gonna have to cross that bridge when you get to it.
Yes.
So tailor the issues that are going to be contested, and then all of y'all have enough experience to decide whether those issues are jury trial issues or a bench issue, okay?
Yes, Your Honor.
All right.
September 1st, Your Honor, at 9:30.
Yes.
Thank you, Your Honor. If we
Okay.
have nothing further, we can be excused.
Yes.
Judge, I have a couple of things that I'd like to bring up.
Sure.
It's been quite a while since I've had any contact with either party in this particular situation. I would like to meet with them as far as to an individual basis, at least one more time before we go. I just, like I say, kind of got blindsided. This case has been going on for quite a while as far as to the issue before the court. So sometime before September 1st, Ms. Williamson and Ms. De Luna, I'm gonna try to see if I can meet with their clients and come up with a more recent opinion as far as to my position regarding the trial.
Okay, and also if you can check your schedule for the next 30 days so that you can also be available for the mediation, Mr. Flores.
I have no problem with that, Judge, and we will try to get everything accomplished and done because this case has been lingering for quite a while. So we have the dates. I'll get a call into Ms. Williamson and Ms. De Luna, and we'll get it all scheduled.
Okay.
Thank you.
Not a problem.
All dressed up and know where to go today, Judge.
Thank you, sir.
We'll
Thank
see
you.
you all
sir.
soon.
Okay, everyone have a great day, okay?
You too,
Thank
Judge.
you.
Okay, thank you. Okay, let me recall CL 163265-I, No Chan 2 versus Kevin Ho. Ms. Palacios Cruz. Can you hear me?
Yes, Your Honor.
Okay, there we go. All right, so this is a continuation on the motion for summary judgment. At the time, we had stayed with Ms. Ramirez needing to do her screen sharing. And I believe she said that she got that worked out. So let me go ahead and turn on my function to allow the screen sharing and we can pick up there. Okay, you should be able to screen share now, Ms. Ramirez. Ms. Ramirez, I don't know, but you're on mute. I don't know if you meant to be on mute.
Just a minute.
Okay.
Oh dear. My computer is not taking what I just a minute.
I really think that storm last night messed up a lot of things.
Yes, I'm almost there. Your Honor, can you see it?
I certainly can.
All right. On my exhibits, Your Honor, that I had asked to and referred to in my motion, I have exhibits A, B, C, and D. The first one has the it just got my name is NGOC THU Faux Bamboo, which I do recognize as the name of that restaurant, and then it's got some numbers, and then Exhibit B, Your Honor, is similar, and it was seems to have different dates and different amounts.
And Your Honor, we have no
However,
objection to the admission of these exhibits. They're going to fall in line similarly to the exhibits that we will be requesting for admission.
all right.
Okay. Well, with no objection, they'll be admitted.
Exhibit C also, Your Honor, which are the admissions, which I have pointed out to the court in my motion, how it talks about not being a verbal agreement on number 8, and how there's no signature of any of the defendant, and how it was prepared by the plaintiff. Then I do have Exhibit D, the affidavit of my client stating that he does not speak very fluent English. A couple of words here and there he does, and that he did register the restaurant in his name in 2015 until 2016, and denying any agreement. So, Your Honor, these have been admitted, and in order to just summarize this motion, if it is a verbal agreement, then they have not complied with the sale of the goods. That must be in writing, sufficient to indicate an agreement under the Business Code, Commerce Code. And if it is a written agreement based on the, then there's no description of anything, no equipment, no names, no sublease. They're alleging that my client represented to sublease the location and to sell some equipment. None of that is clear, none of that is written out. And on the fraud also, those representations are based on the sublease and the equipment, restaurant equipment being sold. And none of that is in writing. And therefore, Your Honor, that's my basis for requesting that you grant us a motion for summary judgment on the breach of contract and the fraud allegations. I'll pass the witness.
Okay, so you can take off your screen share just in case, Miss. There we go. Okay, Miss Velasquez Cruz, you can proceed.
Thank you, Your Honor. We filed the requisite response to a motion for summary judgment, and it's our position that there is a genuine issue of material fact to be heard by the court. I believe neither party asked for a jury trial. We're asking that these issues be decided before by the court. We filed 2 causes of action. As Ms. Ramirez stated, we filed a cause of action for breach of contract and a cause of action for fraud. And Your Honor, as Ms. Ramirez admitted into evidence, there is in fact a receipt for payment for faux bamboo, which is our allegation. So our client alleges that defendant sold faux bamboo restaurant. That payment was made to defendant, and that nothing was received in receipt of payment. And so that is our issue. We have submitted as Exhibit A, our first amended original petition. We also submitted Exhibit D, affidavit of my client, No Chantu. We also attached Exhibit C, affidavit as to the authenticity of the documents he received. Exhibit D, a transcript, and Exhibit E and F. And those are really the issues that we, if I may share my screen.
Yes, it should still be on.
I'm not sure if the court can see that yet.
No. Okay, I can see it now. Oh, you're on mute, Ms. Palacios Cruz.
So Your Honor, the basis of our claim is based on the receipts received from our client, from their client, I apologize, is Exhibit F, Exhibit E, and we ask that they be admitted without objection.
Ms. Ramirez?
Exhibits E and F admitted. Plaintiff's Exhibit E and F.
Okay.
No objection on that.
Okay, being there no objection, they will be admitted.
And Your Honor, I believe they were the same exhibits that Ms. Ramirez had also entered.
Yes.
And these are the writings by Noctu, and this is the sister of the defendant, also an employee of Faux Bamboo at the time. My client is alleging that he made payment at the restaurant to Noctu, which is sister/employee. And we also attached the deposition of defendant, which does acknowledge that she was an employee at the time of this action. So this writing does indicate that she is to sell, or they are to sell Faux Bamboo, and that there was a deposit made. And then Exhibit E is the continuation of that payment. So Your Honor, we believe that there are genuine issues of material fact to be put before the court. And we're asking the court to deny defendant's motion for summary judgment.
Okay. Anything else from either side?
Your Honor, I believe that there is no evidence that as to any other person other than the plaintiff having prepared exhibits E and F. I did ask that question in the admissions, and they were admitted. I believe that the question was if he had, let me see which one, it's 14 and 15. Admit or deny, you did not prepare exhibit A, which is E, and admit or deny that you did not prepare exhibit B, and they're both denied. So those were prepared by plaintiff.
Okay. Anything else, Ms. Palacios Cruz?
And Your Honor, I believe we did move to admit exhibits A, B, C, D. I believe we only moved to admit the last two. So we'd be asking that those be admitted without objection.
Okay, Ms. Ramirez, any objection?
Your Honor, the only objection I have is when the deposition was taken of defendant, they had to use a translator, and that translator did make errors in translating from Vietnamese to English. At that time, I had my own translator sitting next to me, and we did indicate in the record that some of the questions were not being translated correctly.
Did you do your corrections?
No, Your Honor, we did not do the corrections.
Because you should have an opportunity to write those out on the correction sheets and submit them for filing.
But Your Honor, it was kind of impossible because when the question was asked in the Vietnamese, we ourselves could not do the translation. It was very hard to, because that only the English was recorded, not the Vietnamese. So it's impossible to say that this Vietnamese, these words mean these English words. So it was just very difficult to.
And Your Honor, I believe their biggest issue with requesting corrections is that Ms. Ramirez's translator is not a certified translator of Vietnamese. Our translator was a certified translator, so there's no way to certify that Ms. Ramirez's uncertified translator was giving the right translation of the deposition testimony.
Okay. Well, after consideration of the objection, it's overruled and it'll be admitted.
Thank you. And we point out specifically in our response, I'm not sure if the court wants us to go through every single paragraph of the response, but we did point out specifically the deposition testimony that we believe falls in line with our objection to their motion for summary judgment.
Okay. Well, I've read the response as well and also the summary judgment. So I'll submit a ruling within 2 weeks. Make sure that both of your orders are on file.
Yes, Your Honor.
Judge. Nothing further, if I may be excused.
You certainly may.
Thank you, Your Honor.
Thank you. Okay, Ms. Yvette, on F 2456-20-9, number 2 on the court's docket, will you please set a tickler for, let's just say August the 6th, just to make sure that the divorce decree has already been submitted. And the same with the protective order.
Yes, ma'am.
And on Mr. Guerrero's TRO extension, number 8 of the court's docket, let's go ahead and set a tickler for the 30th. And that'll just be for our purposes to see if it's been submitted, because if not, it'll be a moot point.
Okay.
Okay, so all cases were called, and that concludes this morning's docket. We are now